My name is Richard Lee. I'm 25 years a solicitor and I am an accredited mediator. And what I'd like to talk to you about is mediation and the use of mediation for legal disputes and in court proceedings. The question that has to be asked is, why is mediation not used more for legal disputes? And Lord Clark, former Master of the Rolls in England and Wales, gave this answer. The reason why mediation is not used as much as it might be is lack of education. What is required is education of judges, lawyers, both solicitors and barristers, and perhaps more important, repeat clients such as liability underwriters. Put another way, he said, it's education, education, education. So what is the Chartered Institute doing? What we're looking at is fit-for-purpose mediation for court disputes. And arising out of our discussions, we've identified there are two key aspects that need to be addressed. The first is the need to include solicitors and barristers in the mediation process. And the second is the need to accommodate legal requirements and procedures. This requires specific training and the development of core skills. The Law Reform Commission commented that the parties should have access to the procedure of mediation without being obliged to use a legal representative. Nonetheless, it went on to say, the parties should not be prevented from being represented or assisted by a third party. Solicitors and barristers can add value and bring a benefit to the mediation process. Solicitors and barristers can assist their clients engage with the mediation process. Solicitors and barristers can give their clients legal advice during the mediation process. And last but not least, solicitors and barristers can draft the agreement in the event of a successful mediation. The government has stated its intention to bring forward a mediation bill to promote mediation as a viable, effective and efficient alternative to court proceedings, thereby reducing legal costs and speeding up the resolution of disputes. The bill, which is currently being drafted, will introduce an obligation on solicitors and barristers to advise any person wishing to commence court proceedings to consider mediation as a means of resolving a dispute before embarking on such proceedings. The mediation bill will also provide that a court may, following the commencement of any such proceedings, on its own initiative invite parties to consider the mediation option and suspend the proceedings to facilitate such a process. A draft general scheme of mediation bill has been published. And in the draft general scheme, it's clear that there will be a duty on solicitors prior to commencing civil proceedings to advise their clients that mediation be considered and to provide information on mediation. There will also be a duty on solicitors prior to commencing civil proceedings to give names and addresses of mediators, to give estimates of legal costs, and to give an estimate as to how long the court proceedings might take. So what is the Chartered Institute doing? What we're doing is we're developing a fit-for-purpose form of mediation for legal disputes. We are developing core knowledge and skills, and we are educating stakeholders. If you'd like to know more, please contact us